international law, the absence of a centralized executive, legislative, and judicial structure begs the questions: what is law in international law, and where is that law? Previously, and citing legal positivism, we noted that law in international law is what states believe law to be, according to the will and consent of states. As to where this law is, it is found in the sources of international law. And the most authoritative document on international law sources is the Statute of the ICJ, specifically its Article 38(1), which enumerates the sources to be used by the court to settle disputes between states. First, treaties. Treaties are binding written agreements between states and international organizations, and between international organizations. Treaties are legally binding because of the principle of pacta sunt servanda, whereby agreements must be kept and performed under good faith, meaning its terms must not be stretched out and spun away from the original intentions of the agreement. Also, treaties are binding only to states which are parties to the agreement, meaning the states which signed and ratified the treaty. Treaties probably cover all subject matters of international relations, from the conduct of war, to the environment, to trade, to outer space, to humanitarian assistance. However, as stated in Article 53 of the VCLT, treaties cannot be contrary to international law that has the status of jus cogens, translated to compelling law, otherwise termed as a peremptory norm of international law. A peremptory norm is a norm recognized by the international community as a norm from which no derogation is permitted and which can only be modified by a subsequent norm of international law having the same character. Well, let's break this one down. First, a norm to be jus cogens or peremptory must be accepted by the international community as a whole. Thus, it is wrong to go against it anywhere in the world. And second, no derogation is permitted, meaning no state can commit something that derogates or departs or deviates from the said norm. And third, the norm can only be modified by a subsequent norm of international law having the same character, meaning the norm which modifies the original norm must undergo the same treatment, that it is accepted by the international community as a whole and no derogation is permitted. An example of a jus cogens or peremptory norm is the prohibition of slavery. First, there is consensus in the international community that slavery, or owning a human being, is bad. Multilateral treaties against slavery, like the 1926 Slavery Convention and the 1956 Supplementary Convention on the Abolition of Slavery, declare the solidarity of states against slavery. Furthermore, acts and decrees under the domestic law of states, as well as their constitutions, also reflect the consensus against slavery. And second, there can be no derogations in terms of the prohibition of slavery, meaning there can be no exceptions or immunity for certain individuals to own other individuals. And finally, third, changes or modifications to the prohibition of slavery can only be accepted if that change meets the first two requirements. Good luck with that in terms of slavery. Other examples of jus cogens norms are the prohibitions on torture, piracy, genocide, crimes against humanity, and war crimes. All really bad things. But these things happened before, and people learn a thing or two when it comes to these grave crimes. And therefore, maybe, well, let's prohibit these things everywhere in the world all the time. So it would take a lot of convincing if ever these jus cogens or peremptory norms are to be modified. So going back to treaties, states cannot make treaties which are contrary to jus cogens norms, meaning states cannot make treaties which make possible the ownership of humans, or the hiring of pirates, or the utilization of torture, among others. This does not mean states have not done these things before, and some states may still be doing it today, but it's just that states cannot make treaties contrary to the prohibitions of jus cogens norms and have the responsibility as part of the international community to do everything to help police the aforementioned prohibitions. Second is customary international law. Customary international law is made up of two elements, state practice and opinio juris. The first element, state practice, is how states behave with consideration to duration, consistency, and generality of the said practice. Usually, customary international law rules and principles were formed since time immemorial or a very long time ago, like diplomatic rules and protocols. To note, in the North Sea continental shelf cases between Germany, Denmark, and the Netherlands, the court finds that a short period of time is not a bar to the formation of a new rule of customary international law. However, the court noted that state practice should be both extensive or general and uniform or consistent to be considered as a rule or principle of customary international law. Also, in the asylum case between Peru and Colombia, the court declares that the consistency of state practice means that there is continuity and repetition of the said practice. In this case, Colombia claimed that there is a regional customary international law principle on granting asylum to political refugees, and that Peru had obligations to grant safe passage under Colombia's unilateral claim as a state of refuge. However, the court found that there was no strong evidence on a regional custom on asylum. State practice on political refugees and asylum seekers was contradictory and frequently fluctuated. The court decided against Colombia's request, as custom with regards to political asylum with continuous and repetitive state practice was non-existent. Furthermore, state practice need not be absolutely uniform and general, only substantial. The second element, opinio juris, is the psychological factor of state behavior. It asks why states behave the way they do. And to be deemed as a rule of customary international law, state practice must be done according to the belief that the conduct is obligatory under the rule of law. This excludes courtesy, humanitarian considerations, state interest, or any other wise. As cited in the Nicaragua versus US case, there should be evidence of the belief that this practice is rendered obligatory by the existence of a rule of law requiring it, as if it was law in the first place. UN resolutions are pointed to as expressions of opinio juris communis, whenever they are supported by a majority, if not all states, of the international community. As such, UN resolutions on certain subject matters of international law, like those in relation to territory, the environment, and human rights, reflect and cultivate customary international law. All states are bound to the rules and principles of customary international law, except if a state is a persistent objector of a certain rule or principle. This means that since the beginning of the conduct of a rule or principle of customary international law, the persistent objector state had always opposed it. It always said no to the practice. An example would be the Anglo-Norwegian fisheries case between the UK and Norway, where the court declared that the coastline delimitation rule of the United Kingdom, which is treated as custom in the region, is not applicable against Norway. This is because Norway had always opposed any attempt to apply it to the Norwegian coast. The third source of international law is the general principles of law recognized by sovereign states, which references the principles of domestic law common to the legal systems of the world. These general principles are supplementary sources of international law to fill the gaps left by treaties and customary international law. As an example, in the PCIJ's Charzau factory case between Germany and Poland, general principles of domestic law on the obligation to make reparations whenever violations are committed is applied internationally. The general principle of estoppel, or the legal principle which prevents someone from arguing or asserting something that contradicts what they previously said or was already determined by law, is also applicable in international law. Another example includes the principle on the impartiality of judges. There is also the principle of good faith, meaning the terms of treaties are not stretched or warped or used against state parties. As was stated in our previous lesson, the Barcelona Traction case reminded the international community to utilize the general principles of domestic law so to not lose touch with reality. The compilation of judicial decisions and the teachings of highly qualified writers and publicists are the fourth and subsidiary source of international law. Courts, tribunals, and international lawyers do not create international law. In fact, it is important to note that case-to-case decisions of courts and tribunals are only binding to state parties that have consented to the particular court or tribunal. Rather, the decisions of courts and tribunals and the teachings of international lawyers and scholars clarify international law rules, norms, and principles. That is why we cite cases throughout our different lessons and readings, so to offer judicial legitimacy to the interpretations of international law. As to the teachings of highly qualified publicists, these are institutions made up of legal experts which offer insights, clarity, guidance, and legal opinions on international law principles. Examples of these institutions are the International Law Commission, the ILC of the United Nations, the International Law Association, the ILA, and the Hague Academy of International Law. These institutions produce books, journals, and other write-ups in relation to international law. Going further, although the four sources of international law have long been established, states are beginning to engage their relations with other states through soft law. Soft law is an umbrella term covering non-treaty and thus non-binding agreements. These are declarations, codes of conduct, and the administrative laws within international organizations, among others. The interaction between obligation-inducing treaties with convenient and some might say safe declarations and codes of conduct is quite interesting. Soft law may make or break the dependence of states and the international law system on treaties, as soft law may either incentivize and build good relations among states to eventually agree to a treaty regime, or it may remove the incentive on treaties altogether and replace treaties entirely, as it offers little risk with regards to state sovereignty, or a mix between the two possibilities might happen. So there you have it. These are the sources of international law, along with a new sprouting alternative source of international law called soft law. These things are the proof and the result of what the will of states are in terms of the international law system or the rules-based international order. Next lesson, we will dwell how these rules and concepts and underlying theories act out in the subjects and objects of international law, which include states, international organizations, international courts and tribunals, non-state actors, and all other actors in the international system. See you next lesson.